For many people in their 80s and 90s, one common estate planning question is, should I go ahead and transfer ownership of my home or other valuable assets to my children now? It can feel like a generous and efficient way to pass on wealth, but it's not always that simple. The decision has long-term tax, legal, and financial consequences that could either protect or jeopardize your legacy. In today's episode, we'll walk through 5 critical points to consider before signing over the deed or handing over the keys. So Spencer, as we talked about in that intro, this can make sense for certain people to consider, but it's definitely not for everybody. But it's one that comes up when clients start to approach the end of life, especially in their 80s and 90s, and they're seeing, hey, I don't have much longer. So they start asking, should I go ahead and transfer assets to my children? What are some key things that we really need to consider before taking those steps?
Well, the first is, how are you thinking through control and use considerations here? You can actually lose the right to live in the property freely. And this is something that we don't push clients to consider as much, but it's there. If you have a situation where you deed a home over, you are no longer the owner. So if your children feel like it is time for you to move to assisted living, well, now they have the legal capability actually to move you in that direction. Whereas you can dig in your heels far more and stay at home if you still own your home. So the other thing is, it's going to, if you hand over control, you may not know all of the different considerations that your children have in terms of their financial or legal problems, or some that could arise even. All of us drive on the interstate. And so, you can get in a situation, a multi-car collision, heaven forbid, where you have creditors, coming after you. If you don't own your home and your child owns your home, you can have that home taken over by those creditors. So that's another thing. The final thing is in this, if you lose control, there can always be family conflict. And it might be relative to, who is making decisions about, your care going forward. But if you deed over control to one party or multiple parties, you increase the potential that you can't control the conflict that could ensue or the decision. So need to be really careful about handing over control at this stage of your life.
Right. So you're saying that maybe grandson may not like mom when she evicts grandma.
That's possible.
That's possible. Okay, yeah. So we want to avoid situations like that. Second key point, we want to understand any tax implications, especially capital gains. So talk us through this one.
Well, there's multiple considerations here, but the key one is, if you deed over a property, or let's just say you have investments, you have a non-qualified account that you want to give over, or give over management or control of even, you're not going to have a step up in that cost basis when you pass away and pass those resources on to heirs. So a common situation would be, let's say we have patriarch and matriarch. They've lived in this home for 40 years. They maybe even built the home. And let's just say they put $50,000 into this home when they bought it or when they built it. Well, now it might be worth $750,000. Well, if they hand that over right now to son or daughter, the cost basis goes with them. So that $50,000 cost basis goes over to son or daughter. Whereas if they passed away and then the resource went to son or daughter, there's a step up in cost basis. So there's not going to be long-term capital gains in the same way in that particular situation. So you've got to be careful about that. The second thing is that it can trigger gift tax reporting. Now, because the exemption amount is so high for estate exemptions and then lifetime gifts, there's not going to likely be taxes due unless you get above that $14 million threshold per person that we're seeing right now. But still, you will have to report that, I think it's via Form 708 or one of those. You'd need to work with your accountant because you're giving a gift that is above the annual exclusion amount there. So just something to bear in mind. And like we've talked about, overall, the tax efficiency just is not going to be the same there. That step up in cost basis is really critical and really helpful.
Yeah. Okay, so we talked about the tax. Let's talk about long-term care planning, because this is often one consideration that is talked about. If I pass the home to my kids, then it's protected from Medicaid clawback. You want to talk us through that?
Well, the issue here is mom and dad have had this home for so long, and maybe it's even a vacation home, or maybe there's multiple properties here. And let's just say that we have a concern about long-term care, a concern that the facility that will be providing that care would require the home to be sold and take those resources from you. It is a legitimate concern. The reality is, though, protecting against that concern is very difficult. So you would typically need to pass the home along either to an heir or to a trust that would be set up, which, again, you need to talk with your estate planning attorney on this, because there's some who say, we're pretty skeptical about the value of trusts in this area protecting against the state or facilities coming and taking and using the value of those homes. So we need to be careful here. But you've got to have made that decision and gifted those resources at least 5 years in advance of needing long-term care services that would have depleted everything else in your life. So there is a subset of people. Let's just say you have a very, very valuable home, family farm, whatever it might be, and you have no other assets. And maybe you're living on Social Security, and you gift that real estate to the next generation significantly before you would have need of long-term care. That would be one set of circumstances where maybe, it would work out for you. But let's just think about another set of circumstances. You make that gift, and then within a year, you start needing long-term care. Well, if you're not paying for that long-term care, if you don't have any other assets to pay for it, there's going to be a clawback that's going to happen, or the facility may just refuse to give you service there, because they're going to say, no, you're still within the 5-year window, here practically speaking. So the state may not pick up the expense, the facility may not render the service because they know you have assets that you've just transferred within the last 5 years. So this is kind of one of those areas that we always try to help families understand what the trade-offs are here, because it's a rare set of circumstances where you're actually going to have a significant asset, pass that on to the kids, and then have the state foot the bill for mom and dad in a long-term care facility. More common is the asset value is going to help to provide for mom and dad as they have expenses within a long-term care facility. It may not be completely exhausted, because just because you have expense there, if a farm is worth $3 million and you have expense that's $50,000 on an annual basis, that's not going to take the entire value of the farm if the farm is sold. But we do have to grapple with, again, the proper way to go through the estate planning process here.
And if you didn't hear, there were a lot of caveats there. So let's be really cautious, really work with an estate planning attorney if you figure this is the route that fits for you. It does not fit for everyone. There are a lot of caveats. So really be cautious if this is a direction that you want to head. So next, let's consider some alternative strategies like trust or life estates. Can you walk us through these options?
Yeah, so a trust, basically, if you put the resources into a trust, you are naming a trustee who you trust, who will be able to make decisions on your behalf there. But they are held to a fiduciary standard, and you can very clearly articulate the considerations that the trustee needs to take into place. So let's just say that you put together a trust. It could even be an irrevocable trust where you cede control of your home, but you're going to have in there a trustee whom you trust, who's going to be held to the trust document as a fiduciary. And if you say, I don't want to be pushed out of the home under any circumstances, they are required to be in line with that, to hold to that direction. So that's one of the things that can be really helpful, because it removes you from making day-to-day decisions, let's just say, but it allows you to speak to the decisions that you want made. And then when you pass away, also those directions that you want those proceeds to go, or that the value of that real estate to go, you can speak to that as well. A life estate deed can preserve your right to live there. So, in a life estate deed, it allows you to retain the right to live in a home for the rest of your life, but you transfer the future ownership to your children. So not current ownership, future ownership to your children. It can avoid probate and maintain control for you. The challenge is that this is not one size fits all, and different states have different provisions here. So again, work with your estate planning attorney on this. And then the final piece is, sometimes the most effective way to go here is just simply a power of attorney. So you have son or daughter who is named as your power of attorney for financial matters, who can step in should you have cognitive impairment or other things, but you can say very clearly, here are the things that you can make decisions on, here's the things that you can't make decisions on. So they're, again, held to that fiduciary standard. They do not own the asset, so they cannot push you out of the home. They can't say, hey, mom, it's time to move to this facility over here. I actually own the home, and so you can't stay here anymore. Right. In fact, they're just your agent that you've named. So that's a very different type of structure, a different alignment than co-ownership. Because co-ownership can actually be really, really disruptive, which we'll talk about here in a moment.
Yeah. So finally, aligning the transfer with your broader estate plan. Again, we've talked about this kind of in a roundabout way, but this really needs to be worked on with an estate planning attorney in concert with the entirety of your estate plan. So talk us through this piece.
So whether you assign ownership, you make a gift to an heir, or you even make them a co-owner of a particular asset, the challenge is that when you pass away, they own that. So that doesn't really go through your estate plan in the same fashion. It does not go, it's not like those resources that are then in a trust that's going to be distributed out by a trustee. It's not going to go through probate. So if you are a co-owner of a, if you have a joint ownership with right of survivorship account, let's just say, and you pass away, son or daughter then becomes that owner, that full owner of that account. Now, there are certain types of accounts where part of the asset would need to go through probate, and so I won't get into all of that, but there are a lot of situations where that owner just takes over control and they can do whatever they want. So let's just say you owned $1 million account, and that then goes to one son, and another son was not the co-owner on that account. Maybe you trusted this son. Well, that son that you trusted, that you put in place as a co-owner, he doesn't have to give anything to other son, even if it's within the estate plan that it's 50-50. Right. If you're a co-owner and you receive that property at the death of the first owner, then good luck, because now we're in a situation again that is difficult, because you either have son do the right thing that you've told him and specified maybe in your will, but now he has to make a gift that is far above the annual exemption amount. So now he has to record that on his estate plan and going forward in his gift tax return and such. So it's not a great situation regardless. Far better to do a power of attorney or to do a trust type of setup where you have someone making decisions, but actually not having complete control over those assets, or complete ownership, I should say, of those assets.
So, Spencer, thanks for walking us through those key points of what does it look like and what are the implications of granting assets over to children or your beneficiaries. Again, we think about this and we say, you really need to communicate. Whatever the plan is, whatever you and your estate planning attorney decide upon, it's really critical that you have a conversation with those heirs. Hey, this is why I'm doing it. These are my desires. I would even say doing it in writing. Have the conversation in person, face to face, and then say, here it is in writing so that you see it. You have a record that this is the desire. This is the reason that I want to go in that direction. Clients, as always, if you want to talk to us about this, we would love to have a conversation with you. We cannot draft any of these documents. We are not estate planning attorneys. So take this to your estate planning attorney at the end of the day before making any decisions. And as always, we look forward to seeing you again next time. Take care. If you like these financial planning videos, please share with a friend. And if you have questions, go to our website at SiriusRetirement.com. This content was provided by Retirement Planning Services. We are located in Knoxville, Tennessee. You can visit our website at SiriusRetirement.com. The information in this recording is intended for general educational and informational purposes only, and should not be construed as investment advisory, financial planning, legal, tax, or other professional advice based on your specific situation. Please consult with your professional advisor before taking any action based on its contents. Advisory services offered through Retirement Planning Services, LLC.